नमस्ते, आपका कंपनी 360 के यूट्यूब चैनल में स्वागत है और ये वीडियो आपके सामने प्रस्तुत हो रहा है ILMS अकेडमी के द्वारा, जो इंडियाज़ प्रीमियर लीगल एंड मैनेजमेंट एजुकेशन पोर्टल है। गेट सर्टिफाइड टू एनहांस एम्प्लॉयबिलिटी। चलिए मैं आपका स्वागत करता हूँ इस वीडियो के थर्ड पार्ट में। अगर आपने इस वीडियो के पहले 2 पार्ट नहीं देखे हैं तो प्लीज़ जाके देखें। अब हम देखेंगे नॉन एप्लीकेशन द स्पेशल लीगल प्रोविजंस। The special law and procedure created by Section 65A and 65B of the Evidence Act for electronic evidence were not used. Disappointingly, the cause of this non-use does not involve the law at all. India's lower judiciary, the third tier of courts where trials are undertaken, is vastly inept and technologically unsound. With exceptions, trial judges simply do not know the technology the IT Act comprehends. It is easier to carry on treating electronically stored information as documentary evidence. The reasons for this are systemic in India and, I suspect, endemic to poor developing countries. India's justice system decrepit और बहुत poorly funded है। जब तक इंडिया का जुडिशियल सिस्टम मॉडर्नाइज नहीं हो जाता, इंडिया के ट्रायल जजेस इलेक्ट्रॉनिक एविडेंस और उसकी ऑथेंटिसिटी को लेकर हमेशा क्लूलेस रहेंगे। By bypassing the special law on electronic records, Indian courts have continued to apply the provisions of Section 63 and 65 of the Evidence Act, which pertains to documents to electronically stored information. सरल भाषा में कोर्ट्स ने सेक्शन 65A और 65B को इग्नोर कर दिया है। Curiously, this state of affairs was blessed by Supreme Court in Navjot Sandhu, the Parliament attacks case, which was a particularly high-profile appeal from an emotive terrorism trial on the question of defense's challenge to the authenticity and accuracy of certain call data records, that is CDRs, that the prosecution relied on, which were purported to be reproductions of the original electronically stored records. A division bench of Justice P. Venkatarama Reddy and Justice P. P. Naulekar held. According to Section 63, secondary evidence means and includes, among other things, copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy and copies compared with such copies. Section 65 enables secondary evidence of the contents of a document to be adduced if the original is of such a nature as not to be easily movable. It is not in dispute that the information contained in the call records is stored in huge servers which cannot be easily moved and produced in the court. That is what the High Court has also observed in Para 276. Hence, printouts taken from the computers or servers by mechanical processes and certified by a responsible official of a service providing company can be led into evidence through a witness who can identify the signatures of the certifying officer or otherwise speak to the facts based on his personal knowledge. इसके बाद हम देखेंगे इलेक्ट्रॉनिक एविडेंस एंड द इंडियन सुप्रीम कोर्ट. In Som Prakash versus State of Delhi, the Supreme Court has rightly observed that, quote, in our technological age, nothing more primitive can be conceived of than denying discoveries, and nothing cruder can retard forensic efficiency than swearing by traditional oral evidence only, thereby discouraging the liberal use of scientific aids to prove guilt. Schedule changes are needed to develop more fully a problem-solving approach to criminal trials and to deal with heavy workload on investigators and judges. In SIL Import USA versus Eximades Exporters Bangalore, the Supreme Court held that, quote, technological advancement like facsimile, internet, email, etc. were in swift progress even before the bill for the Amendment Act was discussed by Parliament. So when Parliament contemplated notice in writing to be given, we cannot overlook the fact that Parliament was aware of modern devices and equipment already in vogue. In State versus Mohammad Afzal and others, the court held that computer-generated electronic records is evidence, admissible at trial if proved in the manner specified by Section 65B of the Evidence Act. In State versus Navjot Sandhu, the court held that merely because a certificate containing the details in subsection 4 of Section 65B is not filed in the instant case, that does not mean that secondary evidence cannot be given if the law permits such evidence to be given in the circumstances mentioned in relevant provisions, namely Section 63 and 65. नवजोत सांधू की केस में सुप्रीम कोर्ट की फाइंडिंग्स ने इंटेग्रिटी ऑफ प्रोसिक्यूशन एविडेंस के बारे में बहुत सारे अनकंफर्टेबल क्वेश्चंस रेज किए, स्पेशली जो ट्रायल्स नेशनल सिक्योरिटी या हाई प्रोफाइल केसेस जिसमें पॉलिटिकल इंपॉर्टेंस हो उससे रिलेटेड हो. The state's investigation of the parliament attacks was shoddy with respect to the interception of telephone calls. The Supreme Court notes in paras 148, 153 and 154 that the law and procedure of wiretaps was violated in several ways. The Evidence Act mandates a special procedure for electronic records precisely because printed copies of such information are vulnerable to manipulation and abuse. This is what the Veteran Defense Counsel, Mr. Shanti Bhushan, pointed out in Navjot Sandhu, where there was discrepancies in CDRs led in evidence by the prosecution. Despite these infirmities, we should have disqualified the evidence until the state demonstrated the absence of malafide conduct. The Supreme Court stepped in to certify the secondary evidence itself, even though it is not competent to do so. कोर्ट ने printed CDRs को original electronic record से compare ही नहीं किया. Essentially, the court allowed hearsay evidence. This is exactly the sort of situation that Section 65P of the Evidence Act intended to avoid by requiring an impartial certificate under subsection 4 that also speaks to compliance with the technical requirements of subsection 2. जब ऑथेंटिसिटी को लेकर प्रॉपर सर्टिफिकेट की कमी और इंटेग्रिटी ऑफ एविडेंस को पॉइंट आउट किया गया, तभी सुप्रीम कोर्ट ने ये कहा. Irrespective of the compliance of the requirements of Section 65P, which is a provision dealing with admissibility of electronic records, there is no bar to adducing secondary evidence under the provisions of the Evidence Act, namely Section 63 and 65. It may be that a certificate containing the details in subsection 4 of Section 65B is not filed in the instant case, but that does not mean that secondary evidence cannot be given if the law permits such evidence to be given in the circumstances mentioned in relevant provisions, namely Section 63 and 65. In the years that followed, printed versions of CDRs were admitted in evidence if they were certified by an officer of the telephone company under Section 63 and 65 of the Evidence Act. The special procedure of Section 65B was ignored. This had led to confusion and counterclaims. For instance, the 2011 case of Amar Singh versus Union of India saw all the parties, including the state and the telephone company, dispute the authenticity of the printed transcripts of the CDRs, as well as the authorization itself. Currently, in the case of Ratan Tata versus Union of India, a compact disc, that is CD, containing intercepted telephone calls was introduced in the Supreme Court without following any of the procedure contained in the Evidence Act. In Avnish Bajaj versus the state, the question as to what kind of distinction do we draw between internet service provider and content provider was reached. The burden rests on the accused that he was the service provider and not the content provider. It also raises a lot of issues regarding how the police should handle the cybercrime cases, and a lot of education is required. The trend of ignoring the special procedure prescribed for adducing electronic records as evidence was seen even in subsequent cases. In Anwar versus Bashir, the court held that Section 65B of the Evidence Act has been inserted by way of an amendment by the Information Technology Act 2000. In as much it is a special provision which governs digital evidence and will override the general provisions with respect to adducing secondary evidence under the Evidence Act, in 2007, the United States District Court for Maryland handed down a landmark decision in Lorraine versus Markel American Insurance Company that clarified the rules regarding the discovery of electronically stored information. In American federal courts, the law of evidence is set out in the Federal Rules of Evidence. Lorraine held when electronically stored information is offered as evidence, the following tests need to be affirmed for it to be admissible. First, is the information relevant? Second, is it authentic? Third, is it hearsay? Fourth, is it original? Or if it is a duplicate, is there admissible secondary evidence to support it? And fifth, does its probative value survive the test of unfair prejudice? In a small way, Anwar does for India what Lorraine did for US federal courts. In Anwar, the Supreme Court unequivocally returned Indian electronic evidence law to special procedure created under Section 65B of the Evidence Act. The Supreme Court held that provisions of Section 65A and 65B of the Evidence Act created special law that overrides the general law of documentary evidence. Proof of electronic record is a special provision introduced by the IT Act, amending various provisions under the Evidence Act. The very caption of Section 65A of the Evidence Act, read with Sections 59 and 65B, is sufficient to hold that the special provisions on evidence relating to electronic record shall be governed by a procedure described under Section 65B of the Evidence Act. That is a complete code in itself. Being a special law, the general law under Section 63 and 65 has to yield. By doing so, it disqualifies oral evidence offered to attest secondary documentary evidence. The Evidence Act does not contemplate or permit the proof of an electronic record by oral evidence if requirements under Section 65B of the Evidence Act are not complied with, as the law now stands in India. The scope for oral evidence is offered later. Once electronic evidence is properly adduced according to Section 65B of the Evidence Act, along with the certificate of subsection 4, the other party may challenge the genuineness of the electronic record. If the original electronic record is challenged, Section 22A of the Evidence Act permits oral evidence as to its genuineness only. Note that Section 22A disqualifies oral evidence as to the contents of the electronic record. Only the genuineness of the record may be discussed. In this regard, relevant oral evidence as to the genuineness of the record can be offered by the examiner of electronic evidence as expert witness under Section 45A of the Evidence Act, who is appointed under Section 79A of the IT Act. In Sanjay Singh Ramrao Chavan versus Dattatreya Gullabrao Phalke, the court, relying upon the judgment of Anwar case while considering the admissibility of transcription of recorded conversation in a case where the recording has been translated, it was held that as the voice recorder had itself not subjected to analysis, there is no point in placing reliance on the translated version. Without source, there is no authenticity for the translation. Source and authenticity are two key factors for electronic evidence. In the recent judgment, Jagdev Singh versus the state and others, pronounced by Honorable High Court of Delhi while dealing with the admissibility of intercepted telephone call in a CD and CDR, which were without a certificate under Section 65B Evidence Act, the court observed that the secondary evidence without certificate under Section 65B Evidence Act is inadmissible and cannot be looked into by the court for any purpose whatsoever. Now, after going through two parts and this video, we will look at the conclusion of this topic. Strict compliance with Section 65B is now mandatory for persons who intend to rely upon emails, websites or any electronic record in a civil or criminal trial before the courts in India. This outlook of the Supreme Court of India is to ensure that the credibility and evidentiary value of the electronic evidence is provided for, since the electronic record is more susceptible to tampering and alteration. In his judgment, Justice Kurian observed that electronic records being more susceptible to tampering, alteration, transposition, excision, etc., without such safeguards, the whole trial based on proof of electronic records can lead to travesty of justice. Therefore, the computer-generated electronic record cannot be solely relied upon, because there is a possibility of it being hampered. The Indian Evidence Act could be further amended to rule out any manipulation, at least for the purposes of presuming prima facie authenticity of the evidence of the electronic record, by adding a condition that the record was created in the usual way by a person who was not a party to the proceedings, and the proponent of the record did not control the making of the record, by ensuring that the record was created by a party who was adverse in the interest of the proponent of the record, and the record was being used against the adverse party. The risk of the manipulation of the records would be reduced significantly. This is because it is argued no disinterested party would want to certify the authenticity of the record which to his knowledge had been hampered with. The law also needs to creatively address the requirement of the burden being on the proponent to provide testimony as to the author of a document to determine whether there was any manipulation or alteration after the records were created, the reliability of the computer program that generated records, and whether the records are complete or not. कोर्ट्स को इस बारे में भी बहुत ध्यान रखना चाहिए कि डेटा बहुत इजीली फोर्ज या ऑल्टर किया जा सकता है, और सेक्शन 65B इन कंटिंजेंसीज को एड्रेस नहीं करता है. For instance, when forwarding an email, the sender can edit the message. Such alterations are often not detectable by the recipient, and therefore a certificate of the third party to the dispute may not always be a reliable condition to provide for the authenticity of the document. Serious issues have been raised in the digital world due to malpractices such as falsification of information and impersonation in relation to the authenticity of information relied upon as evidence. It raises queries as to how it is possible to prove the creation and transmission of electronic communication by one party when the party's name as the author of the post could have been inserted by anyone. Perhaps it may be prudent for the courts or the government to set up a special team of digital evidence specialists who would assist the courts and specifically investigate the authenticity of the electronic records. the challenges with respect to the admissibility and appreciation of electronic evidence in India still has a long way to go in keeping pace with the developments globally. Although the amendments were introduced to reduce the burden of the proponent of records, they cannot be said to be without limitations. It is clear that India has yet to devise a mechanism for ensuring the veracity of contents of electronic records which are open to manipulation by any party by obtaining access to the server or space where it is stored. The admission of electronic evidence along with advantages can also be complex at the same time. It is upon the courts to see whether the evidence fulfills the three essential legal requirements of authenticity, reliability, and integrity. After Anwar's case decision by the Supreme Court laying out the rules for admissibility of electronic evidence, it can be expected that the Indian courts will adopt a consistent approach and will execute all possible safeguards for accepting and appreciating electronic evidence. To understand this topic deeply, you can take the certificate course on electronic evidences given by ILMS Academy. This course gives you a detailed overview about what are electronic evidences, how to procure electronic evidence, and details thereof. After watching 3 parts of this video, you should really consider taking this course. तो इसी के साथ ये वीडियो समाप्त होता है. Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability. Thank you for watching this video and have a nice day ahead.